Okay, so let's talk about some of the personalized protections that you can get in creating an estate plan through your trust. Protection from creditors, remarriage protection, divorce protection. So I'm going to say protection in quotes, um, and I'll explain this in a little bit. So it has been historically that trusts were made such that they could prevent a beneficiary's creditors from reaching into the trusts to be able to use the trust assets to satisfy a beneficiary's creditors. Okay. So, kind of breaking it down as an example, let's say you've got a beneficiary, they're not so great with money. They have a lot of credit card debt. They've got, maybe they get in an accident. We'll talk about this in a little bit. It used to be that through, if the assets were left in trust for them, it would prevent a creditor from reaching into the trust that you made for your child after you've passed away, or for this person, whether that's your spouse or your child after you've passed away. It used to be that there was protections that would prevent creditors from reaching up into the trust to satisfy the beneficiary's creditors, okay, the beneficiary's debts. However, California's Supreme Court in the Carmack case, and I believe that was fairly recentish, 2019, I want to say, maybe 2017, could be 2019, I think. Basically, the California Supreme Court in the Carmack case found that no, there really isn't creditor protection in that sense. If you have a trust that provides that assets can come out of that trust for the benefit of your beneficiary, again, whether that's your surviving spouse or your child, if it could come out for their health, education, and maintenance, then that beneficiaries, creditors can reach up into the trust to satisfy that beneficiary's creditors. Okay. So that being being as it may, I'm still going to talk to you about the concept of how trusts work, because it will come in handy in explaining a couple things here. So we've got Bill and Mary here. Bill and Mary are high school sweethearts, and they've been together for a very long time. They've got two kids here, Bobby and Susie. So Bill and Mary have everything. They built everything together. They didn't really have anything because they were married so young. They didn't have anything separately. Everything they built together during their marriage. So whatever it is they have is called community property. They have a joint bank account. They buy a house. They have both of their names as husband and wife, community property, maybe husband and wife as joint tenants for deeds on the house. Okay. So, what happens in this circumstance when Bill and Mary, they don't have an estate plan? Okay. And what happens when Bill passes away? Okay. In that circumstance, everything that is held jointly, everything ends up passing to Mary. Okay. So everything passes to Mary from Bill as to assets that are held jointly. So Bill passes away. Mary goes down to the bank with the death certificate and shows them that Bill has passed away. So great, Mary's the joint owner. Everything goes to Mary. As far as the deed to the house, Bill has passed away. Mary records an affidavit of death of joint tenant, and now the house is Mary's. Okay. So let's say everything is in Mary's shoes. And this part of the image, it popped up a little bit too soon here. But let's say Mary is driving home from the hospital, so distraught after having lost Bill, and she runs a red light and she ends up hitting a school bus. Three kids are killed, judgment against Mary for $3 million. In this circumstance, in this circumstances, the family goes to Mary and they say, Mary, pay up. And Mary says, well, I've got insurance on the car. Okay, well, the insurance on the car is $1 million. The judgment's for $3 million. And they say, where's the other $2 million? In that circumstance, I guess the question for you is that can the family of those children, can they reach Bill's assets? Okay, Bill has passed away. I'll let you think about that a little bit. So the answer is yes, because those Bill's assets have now become all of Mary's assets. There's a saying that your creditors stand in your shoes. If you can reach those assets, so can the creditors. Okay. So after the families of the remaining $2 million judgment, they take whatever it is Mary has. And in that situation, we would say Mary now and the kids are in a really bad situation. Okay. So how can we plan through trust in this situation to maybe prevent this? So this is a side view of the box. Okay. The side view of the box, it's open on the top. And this little squiggly line in the middle just represents a piece of Velcro. Okay. It's like a piece of Velcro that holds these two sides of the box together while Bill and Mary are alive. Okay. So into this box, they're going to put 100% of their community property assets and 100% of each of their separate property assets. So separate property are assets that you acquire prior to your marriage, which you keep separate in the marriage, or it is gifts or inheritances that you receive during the marriage that you also keep separate. Okay. But in this circumstance, we identify everything, we put all those assets into the box. So once husband passes away, this box that was held together by Velcro can split now into two separate trusts. We have what's called the survivor's trust and the decedent's trust. So into each one of those boxes, we're going to split one half of the community property and 100% of the separate property. Okay. Here in this situation, because the decedent is dead, the box, if you remember, after you've passed away, it closes. Okay. So as we like to say, the trust becomes irrevocable or irrevocable, meaning the terms of the trust regarding the assets in the decedent's trust cannot be changed at that point. Okay. But you notice here on the survivor's trust, there's no box, there's no lid on that box because the survivor is surviving. He or she is still in this situation with the spouse, she's still alive. Okay. So the beneficiary of each of these boxes is the surviving spouse, typically, okay? Meaning all of the assets that are in both of these boxes can only come out for the surviving spouse's benefit. Many people will think, well, if my spouse dies, does that mean I can't get access to what is in the decedent's trust? And that cannot be further from the truth. No, typically, the surviving spouse is the only beneficiary during his or her lifetime. Okay. Assets can only come out of the decedent's trust for the surviving spouse. Okay. From the decedent's trust. And if you see on the survivor's trust, it's the same as well. The assets in the survivor's trust come out just for the surviving spouse. Excuse me. There are circumstances that we will name children or other beneficiaries as beneficiaries of the decedent's trust during the surviving spouse's lifetime. This is usually where children are minors. Okay. And the trustee or who is in charge of distributing the assets from the survivor's trust is the surviving spouse. And the surviving spouse is or can be also the trustee of the decedent's trust. Okay. So in this circumstance, the surviving spouse is responsible for making distributions from both the decedent's trust or this from the decedent's trust for the HEMS, for health, education, and maintenance of the beneficiaries of the decedent's trust, which in this instance is the surviving spouse themselves and the minor children. Okay, health, education, and maintenance is a fairly broad definition. It's what we call ascertainable standards. And it just means that's going to take care of health insurance, anything that has to do with medically related. Education, I think that's fairly straightforward. Doesn't necessarily have to mean college education. It can just mean vocational schooling as well. And maintenance. It's to maintain the lifestyle that they had. Okay. So in that circumstance, now, if we have it set up for a trust, when Bill passes away, whoops, when we have it set up in a trust, when Bill passes away, what happens here is now the the families of the deceased children come to the, oh, excuse me, I'm trying to highlight, ooh, excuse me. In this same circumstance, if we have the assets set up in trust like this, the family members of the children that were killed in the bus crash would come to the surviving spouse and they'll say, Mary, here's a judgment for $3 million. Mary gives them the $1 million from the insurance, and they say, well, that's not enough. And we have $2 million more that you owe us. In that circumstance, because Mary is the survivor and Mary was the one who was in the accident, so she is actually what we call the debtor. Okay, the families are called the creditors. Mary has to give those families what is in the survivor's box because that box is open. Okay, it's not protected. Mary can access it whenever she wants. She can control everything from that. Okay, so as I said, your creditors stand in your shoes. If you can reach it, so can they. So Mary does have to give them whatever's in the survivor's trust. In this circumstance, then, if that's not enough and they try to get into the decedent's trust, to satisfy the judgment. Pre-Carmack, it used to be that leaving the assets in the decedent's trust would protect those assets from the excuse me, from the beneficiary's creditors. Post Carmack, if money is coming out for Mary, she's the surviving spouse. Mary is a beneficiary here. If money is coming out for her health, education, and maintenance from the decedent's trust, then there is an argument that the creditors can make that they can actually reach up into the decedent's trust to satisfy the debt that Mary, as a beneficiary, owes. So you say, well, that's not really that great. If that's the case, why do we still plan with trusts? That being said, even post Carmack, we can still create trusts that do offer creditor protection. However, it's very restrictive as to when those distributions can come out. Okay, the distributions don't come out for health, education, and maintenance. They are a totally or complete discretionary distribution standard, meaning whenever the trustee decides, okay? And in that circumstance, the trustee is not going to be the surviving spouse. It most likely is going to be just a neutral third party, an independent third party, like a professional fiduciary or whatnot. So is creditor protection available? It still is. It's just in a much more restrictive setup. And I find typically that clients are not in a situation where they're wanting to limit the surviving spouse from access to the assets in the decedent's trust on the off chance that there may be creditors. But certainly the creditor protection planning is available from the standpoint of the irrevocable trust on the decedent side. Okay, there is no creditor protection at all for the assets in the survivor's trust, and it cannot be planned for.